Yes, a warm welcome and a very good morning, good afternoon, whatever may be. First thing, we are here for a quick revision for CS EET legal aptitude. We are here to revise legal aptitude, and almost there are 5 chapters in your legal aptitude which we are covering. Today we are starting with the topic which is called as law relating to torts. Let me give you an idea what is a tort. Okay, the very first thing, tort means something wrong done with anyone. Tort means something wrong done with anyone. There is a word tort, there is another word tortum, and there is a word wrong. Everything means the same. The only difference is the language. Tort is a word from French language. English word is wrong and the Latin word is tortum. So can we tell tort is equal to tortum, that is equal to wrong? Yes or no, friends? Just put in the comment section. Tort means tortum, that is equal to wrong. So tort is a French word. Similarly, tortum is the Latin word and English word is wrong. So can I write this way? Tort is equal to tortum, that is equal to something wrong happened with someone. Okay, so tort is which word? If I'm seeing this, tort is French word. Okay. Tortum is which word? Tortum is Latin word and wrong is a common English word which means one and the same. So if any wrong happened to someone, if anything wrong done to someone, can he file a case of tort in the court of law? Can he file a case of tort in the court of law? Answer is yes. Answer is yes. So basically tort French word, tortum Latin word, and there is something which is called as wrong, which is an English word. So let me explain you this in detail. Let me give you more example. See, wrong are of two types: civil wrong, criminal wrong. Civil wrong means a wrong which is done to a particular person, and criminal wrong means basically a wrong done to the whole society. Suppose example, there is A who promised to sell the car to B, but A did not give the car but take the money. It is civil wrong or criminal wrong? Please put in the comment section. Yes, those are watching, tell me. I am repeating my question. A promised to sell the car to B. B has paid the money, but A did not give the car. Tell me, it is which type of wrong? Civil wrong or criminal wrong? It is civil wrong. Okay. A has promised to sell the car, but instead of selling the car, okay, but he go and murder the person. It is civil wrong or criminal wrong? If you go and murder the person, it is criminal wrong. So wrong is of two types. One is civil wrong and one is criminal wrong. Basically the wrong which is, understand here, any wrong can be divided into two types. The first wrong is civil wrong and the second wrong is criminal wrong. Okay, civil wrong means what? Something which is wrong to a particular person. Wrong to particular person. Bear with my writing, I am repeating again. Okay, there are two types of wrong, that is civil wrong, criminal wrong. Civil wrong is done to a particular person, but when the wrong is done to large public, wrong to large public, guys, it is which wrong? Criminal wrong. So tort comes under which wrong? Does it come under civil wrong or it comes under criminal wrong? Tell me, friends, what do you think? Yes, it is a civil wrong. So basically in civil wrong there are two types of wrong. One is breach of contract. You promise something but you do not perform it, that is breach of contract. And others are tort. Others are tort. So basically we can tell tort is a type of civil wrong which is done but which is not breach of contract. Suppose there is a contract and I am promised to sell you the car. I did not sell you the car. That is a civil wrong and it is a breach of contract. But there is a car. I opened your car without your permission. I opened your car with a duplicate key and go and sit in your car. It is not breach of contract. It is tort. It is not breach of contract. It is tort. Do you understand this? Yes or no? So both are civil wrong, but one is breach of contract and one is tort. Are you understanding this? Yes or no, friends? Are you listening? Come on, guys, you have to answer. So basically, wrong are of two types: civil wrong, criminal wrong. Those wrong done to particular person is a civil wrong, and those wrong done to a large public is a criminal wrong. In civil wrong, there are two types: breach of contract and tort. When you promise something but you don't do it, that is breach of contract. And other, what is not breach of contract is tort. So tort means totem, that is means wrong. Tort is which word? Tell me. Tort is derived from which language? French language. Okay. Totem is derived from which language? Latin, which equal to English word called as wrong, which means English word called as wrong. So this is the whole discussion of wrong. That is civil wrong, criminal wrong. Civil wrong means breach of contract and tort. Are you guys comfortable till here? Yes or no? Yes or no? Sorry. Yes. Now let us understand the further discussion. Now let us understand the further discussion. Let me explain you some more about detail in tort. For tort, there must be three elements. There are three elements. So what are the elements? Let me understand. For tort, there are three elements. Let me open. Yes, I come to this. For tort, there are three elements. The very first element for tort is elements of tort. To become tort, there should be three things. First thing is there is some wrongful act done, some wrong done. Wrongful act done. Wrongful act done. Second is it is a legal damage. And third is there is a legal remedy. Understand what I'm trying to tell. There is a legal damage and there is a legal remedy. Legal remedy. Sir, what is all these things? To become a tort, there should be three things. If these three things are present, it is a tort. If these three things are absent, it is not a tort. I am repeating again. To become a tort, there should be three elements. The first element is wrongful act. Second element is legal damage. And third is a legal remedy. Understand here. Sir, what is wrongful act? See, everyone have a right. Everyone have a personal right. What are the personal right? First right. Okay, the first right is right of reputation. Everyone should get a respect. You cannot tell, you cannot defame someone. You cannot blame someone for unnecessary reason. Second is right of property. You cannot enter anyone's property without permission. Right of property. And third is basically right of bodily safety. Right of bodily safety and freedom. Bodily safety and freedom. There are three rights. Suppose example, without any reason, you print any article against me and you're trying to defame me. Is it something wrong done to me? Yes or no? Or without any reason, you enter my home without my permission, come and sit for 20 minutes and go without my permission. You are entering my property. That is not allowed. That is my right of property. How can you enter? Without my permission, you are touching me or pushing me. That is not allowed. That is right of bodily safety and freedom. So if someone is defaming someone, or if someone is doing trespassing, what do you mean by trespassing? Trespassing means to enter the property without the permission. Trespassing means to enter the property without permission, or someone is touching someone without the permission. Tell me, friends, is it a rightful act or wrongful act? What is the answer? It is a rightful act or wrongful act. Again, I am repeating. If someone is defaming someone without any reason. It happened that like Rahul Gandhi said a statement, "Chokidar chor hai." So by this statement, he's telling Prime Minister a chore. So against Rahul Gandhi, there was a defamation case. How can you defame? Prove it. How can you tell this way? Okay. Or anyone comes to my property without my permission, enter my hall and a kitchen without my permission. Rightful or wrongful act? It is a wrongful act, right? Similarly, anyone is touching anyone, pushing anyone, that is again a wrongful act. All these things are wrongful act, very, very clear. So if I'm talking about right of reputation, if you are defaming someone, defamation, it is a wrongful act. Right of property, if you enter the property without permission, it is called as trespassing, which is wrongful act. And right of bodily safety and freedom, there are two examples. One is battery and second example is assault. Battery and assault. So what is battery, what is assault, we'll talk. Okay, so all these things, if someone is doing defamation, if someone is trespassing without permission, they are entering a property, or there is battery or assault, then all these are basically wrongful act, which is basically wrongful act and will be considered as tort. So you write down this chart first. Please note down the chart. I'll zoom this chart. Is it done? Again, I'm repeating. For elements, there are three elements. One is wrongful act. Okay. Second is legal damage. And third is legal remedy. For wrongful act, there are three rights. That is right of reputation, right of property, and right of bodily safety and freedom. If someone, instead of reputation, they defame it, or they enter the property without permission, or they do battery or assault, then that is a wrongful act. Very clear, guys. I'll show you in the book also. Just hold on. See, understand here. We'll read what is taught. The word taught is a French equivalent word of English word wrong. The word taught is derived from the Latin word totum. The word taught is derived from the Latin word totum. Thus, simply stated, taught means something wrong. But every wrong is not taught. Every wrong is not taught. Example, there is a ad सर्फ एक्सेल. हर दाग बुरे नहीं होते, हर दाग taught नहीं होता है. Every wrong thing is taught or not taught. Tell me, anything wrong happened is a taught or it can be breach of contract, is a taught or it can be crime. Every wrongful thing is taught, true or false. Tell me, every wrongful thing is taught, true or false. What is your answer? I am repeating the sentence. Every wrong thing done is a taught. True or false? False. Every wrong thing is not taught. Some wrong thing is breach of contract and some wrong thing is crime. Some wrong thing is breach of contract, some wrong thing is crime. But tort is which type of wrong? Civil wrong. देखो, tort is really a kind of civil wrong as opposed to criminal wrong. Okay. Wrong in law can be either public wrong or private wrong. When it is a public wrong, when it is a public wrong, then it is a crime. But tort is a civil wrong which is not breach of contract or breach of trust. Tort is a civil wrong which is not breach. If it is not breach of contract, then it is a tort. Are you able to get this? So basically, the tort means a civil wrong which is not breach of contract or breach of trust. Very, very clear. To understand this, elements. How many elements are there? Tell me. How many elements of tort are there? Question to you guys. Come on. Three elements are there. What are the three elements? The first element is wrongful act. Second element is legal damage. And third element is legal remedy. The first element is wrongful act, second element is legal damage, and the third element is legal remedy. There are three elements. If I am talking about wrongful act, everyone have a right of reputation. Everyone have a right of bodily safety freedom. Everyone have a right of property. If someone is defaming someone without any reason, if someone enter the property without permission, and if someone does battery assault, it is called as wrongful act. It is called as wrongful act. Please read this. Yes, guys, tell me, if someone is defaming someone, if there is what bodily safety and freedom, someone is assaulting someone. See, there was a case by Arnab Goswami, a media editor. Obviously, he's a chief media head, and in Republic Bharat, where he was arrested from his house. He filed a case against the police for assault. The police is being threatening him to hit. He was claiming that he was being threatened to hit. So actually threatening to hit is assault and actually hitting is battery. If someone go and hit someone is what? Battery. If someone go and just show so that is what assault. So what is my point here? To be very frank, to be very clear, the first thing is that if someone is defaming someone or someone is doing assault or battery or someone is trespassing without means entering the property without permission is called as wrongful act. Do you understand this? Are you guys listening? Please tell me yes or no in the comment section. Come on faster. Yes or no? Yes. So what is my point here? For wrongful act, there are three things. Now, what is legal damage? In legal damage, second element, there are 2 points. Legal damage, there are 2 points. The first point is, that is what we call as, that is damnum sin injuria. Okay, you must have studied this. Damnum sin injuria and injuria sin damnum. How many know this? Please raise your hand. How many know this? Tell me. Very good. Fantastic. Okay. Okay. So there are two things. That is, first is damnum sin injuria, and second is injuria sin damnum. So what is this? See, damnum means damage. You know, there is money loss, there is comfort loss, there is some loss to you. But sin means without. What do you mean by injuria? Injuria means without impacting your legal right. Example, suppose I start a shop and I'm earning 20 lakh rupees per annum. I'm selling clothes. Mr. Ramlal, who now competing with me, he started the shop next to me and is competing with me. Because of Ramlal, my profit is reduced to 10 lakh rupees per annum. Now tell me friends, because of Ramlal, there is monetary loss, yes or no? Because of Ramlal, I have a monetary loss, yes or no? Tell me friends, what do you think? Because of Ramlal, there is monetary loss, yes or no? Answer is yes. So that is called as damnum. That is called as damnum, means there is a damage. But can I file a case against Ramlal to recover the loss? Yes or no? Can I file a case against Ramlal to recover the loss? Yes or no? No, because Ramlal has not done anything against my legal rights. Ramlal has not done anything against my legal rights, and therefore that is there is a damage. There is a monetary loss. but there is no infringement of my legal right. He is not contravened any of my right. He is just competing. So because of Ramlal, there is a discomfort to me. Because of Ramlal, there is loss of money also. But basically, if I'm talking about Ramlal has not done anything to my legal right. Has he done defamation? No. Has he done anything against my right of property? No. Has he done anything against my personal safety and freedom? No. So basically, there is a damage, but there is no injury. I cannot file a case against Ramlal. In short, always every monetary loss you cannot file a case. If there is a monetary loss, it doesn't mean you can file a case. There should be contravention. There should be a contravention of the legal right. There should be a contravention of the legal right. Are you able to get this? Are you able to understand this? Yes or no? Yes or no? Are you understanding? So I'll take another example. Suppose, see what is damnum? Damnum means there is damage without injury, and injuria means there is injury without damage. I'll explain. Suppose example, one of these students, suppose Anisha enter my place without my permission. Anisha come to my place, sit, watch IPL match 2 hours and leave. She did not touch a single thing. She did not harm anyone. But she entered my property and for 10 minutes she's watching IPL match and then she leave. And I was worried because an unknown person is coming to my home. Are you able to understand this? This example. So my point is, did Anisha do any harm or loss to me? Yes or no? Do Anisha have done or is Anisha have done any act by Anisha which is causing a monetary loss to me? No monetary loss to me. But is she has done any contravention of my right? Is she has breached my legal right? Yes or no? Yes. Answer is yes. I have a right of property and now Anisha cannot enter my property without my permission even though she has not done any damage but she has done injury. Even though she has not done any damage, but she has done injuria, I can file a case against Anisha and recover the damage. I can file a case of tort, even though there is no monetary loss. Even though there is no monetary loss, this is called as injury without damage. She has infringed my right. She has infringed my right, but she has not done any monetary loss. But still, I can file a case. If any other person has done monetary loss but not infringe, not contravene my right, I cannot file a case. So tell me, in which case you will file a case? Situation number 1 or situation number 2? In which case you have a right to file a case? Situation number 1 or situation number 2? Yes, guys, in situation number 2, I can file a case. In situation 1, I cannot file a case. Very, very clear. So, first thing, there should be wrongful act. That wrongful act must contravene your legal right, whether it is causing a loss or not causing a loss, whether there is monetary loss or no monetary loss. If there is a wrongful act through which your legal right is being infringed, then that is called as injuria. That is called as injuria, whether with damage or without damage, you can file a case. Very, very clear. So, guys, in this case, I'll write an example here. A started competing. A started competing with B, due to which B is having reduced profit. A started competing with B, due to which B is having reduced profit. Can B file a case against A? Tell me yes or no. Can B file a case against A? Tell me yes or no. Answer is no. There is a damage. There is a damage, but there is no injury. There is no, B is not doing, A is not doing any wrong against the legal rights. Okay. But here example will come up. Example, A entered B's house without permission. My writing is little international, but I'll dictate it. Don't worry. Entered B's house without permission, but did not do any physical harm. I'm zooming this. I'll read everything. Legal damage are of two types. Legal damage are of two types: damnum sin injuria and injuria sin damnum. Damnum sin injuria means damage without injury, and injuria sin damnum means injury without damage. Very clear? Example is A started competing with B, due to which B is having reduced profit. A started competing with B, due to which B is having reduced profit. It is called as what? It is called as there is a damage, but there is no injury. But A entered B's house without permission, but did not do any physical harm. But still, you can file a case because there is injury, even though there is no monetary damage. Are you understanding this? Are yes or no? Are you guys connected? So first thing, how many elements are there? For tort, there are three elements. The first element for tort is basically the wrongful act, and that wrongful act is need not harm you, but if it is impacting your right, then you can file a case. Now when there is something wrong, then you have a right to file a case and recover the damage. Then there is a remedy. The first remedy is, can you claim damages from the party? Tell me yes or no. Can you file a case against the person and recover damage? Tell me yes or no. Yes, but which damage? There are two types of damage. One is liquidated damage and another is unliquidated damage. So what is the difference between liquidated damage and unliquidated damage? Tell me, friends. What is the difference between liquidated damage and unliquidated damages? See, when the damage is decided by the parties, it is liquidated damage. When the damage is decided by the court, that is unliquidated damage. There is a difference. Again, I am repeating. When the damage is decided by court, decided or fixed by court, so that is called as unliquidated damages. That is called as unliquidated damages. If it is decided by the contracting parties, it is called as dash. Tell me what dash. If it is and decided by contracting parties, it is called as liquidated damages. So when tort happens, the court will decide and the court will pay you which damage? Unliquidated damage. Second is, can you get a stay order? If someone is entering your house without your permission, can you get an injunction order stopping the person from entering your house or entering your property? Yes or no? So what is injunction? To stop someone. Injunction means to restrain someone and to stop someone. That is called as injunction. And third is, you need not go to court for self-help. Atmanirbhar Bharat. Some drunkard is entering your house and he is dancing that way. and he's having that bottle, he'll hit you. You want to protect your family. To protect your family, you just make a hit him and put him outside your house. Tell me, do you need to go to court for this, or self-help is the best help? Self-help is the best help. So there are three remedies. The first remedy is claim damage. Second remedy is take injunction order, stay order, and third remedy is self-help. Are you understanding this? So this, what are the legal damages? What are the legal remedies? The first remedy is unliquidated damages. Unliquidated damages. Second remedy is injunction, and third remedy is self-help. When there is a problem, there is a remedy. Do you understand this? Self-help is the best remedy. Please write down this three remedies. Unliquidated damages, injunction, so guys, how many elements are there? Tell me, repeat. How many elements are there? Tell me faster. How many elements are there? Three elements. What are the three elements? There is some wrongful act, there is some legal damage, the legal right is conferred, and there is legal remedy. How many remedies are there? Three remedies. First is claim damage, unliquidated damage. Second is injunction, get a stay order, and third is self-help. Very, very clear. Okay. Now, wrongful act. If there is a right, there is right of property, right of reputation, and right of bodily safety and freedom. If someone is defaming you, if someone enter your property without your permission, that is trespassing. And someone is basically doing anything against your bodily safety and freedom, like battery assault, there is a wrongful act. And such things should be contravening your legal right. Whether you have suffered a loss or not suffered a loss, that is not important. If your right is being contravened, there is a tort. And when your right is being contravened, then you have a right to take a legal action, which is called as legal damage. And they recover the money, recover damage, get the stay order, and self-help. Very clear. So let us discuss what are the things which are against the personal safety and freedom. What are the things which are against personal safety and freedom? I'll explain you one by one. What are the things which are taught against personal safety and freedom? Let me give you examples. Okay. See, the tort or the wrong which are against the personal safety and freedom, which is against the personal safety, battery. If you go and apply a force, if you hit someone, if you push someone, if you touch someone without any lawful justification, without any consent. See, if you want to touch also, you need to take the consent of the party. Okay, suppose there is a small baby and he is belonging to some family. You go to a garden. Nowadays in COVID pandemic situation, everyone is like to be far away. If you want to take the baby and play with that baby, do you need to take the consent of the family? Yes or no? Tell me. Or you can directly grab him. You need to take the consent. So basically, if you go and hold anyone, touch anyone, push anyone, that is a tort and that is punishable, which is called as battery. Which is called as battery. Very, very clear. So battery means direct application of force. Battery means direct application of force either without consent or without lawful justification. There are two things. If you have, see, if by law court has ordered to arrest you, pick you up and put in jail, police is holding you and putting inside the jail, is it a battery? Yes or no? My question is, there is a court order wherever you are in whatever situation, arrest you, And if you are not listening, push, pull, and get him. And the police is now pushing, pulling you to get in the court because you are not ready. Is it a battery? Tell me yes or no. No, police with the court order is arresting you. That is not battery. But without any reason, police is putting you behind the bars just to harass you. Without any court order, they are arresting you for 20 days, detaining you for 20 days. Is it a battery? Yes or no? Yes, very clear. So for a battery, there should be application of force. See, now we are talking about taught or wrong. Taught or wrong, which is against safety, personal safety and freedom, which is against personal safety and freedom. Okay, guys. So now the first is battery. And what do you mean by battery? Battery means applying force either without consent, without taking the permission, without consent, or without lawful justification. Without lawful justification. Without consent and without lawful justification, it is called as battery. Very, very clear. To apply physical force, touch, push, pull, hit, put a rod, that is a battery. Write down this. First is battery. What is second? Assault. Assault means trying to show impression that you will trying to do battery. Means you're not actually touching, but you're showing. Means you're trying to create an impression that you will do battery. But are you doing battery? No. But you're making impression. You are threatening the party, not by hitting, but trying to hit, trying to show. Correct. So that is assault. So actually, assault, if the party then really hit you, then that is what called as. If the party really hit you, then that is what called as. Yes, Harshit, right? If the party really hit you, that is a battery. But if they create a impression that they will hit you, if they create impression that they will hit you, then it is called as dash. If they are trying to create impression, then that is assault. Very clear, Pavana. Very clear. That is assault. So if you see this in assault, there is a impression apprehension. The act creates an apprehension in the mind of the plaintiff. Plaintiff means who's filing a case that he is going to commit battery against him. Such type of tort is called as assault. Clear? What is assault? Any act which creates apprehension in the mind that, what do you mean by apprehension? Impression. Apprehension in the mind that the other party will do battery. If you want, you can write from this yellow part. Write down this. Any act which creates apprehension in the mind of the plaintiff that he is going to commit battery against him, then the tort is called as assault. Tort is called as assault. Very, very clear. Tort is called as assault. So battery means you are applying force. Assault means you are trying to create impression that you will be applying force. That is called as assault. False imprisonment, putting behind the bars without any reason, stopping the bodily freedom to move from one place to another place, detaining someone, keeping in the custody, locking in a flat, locking in a godown, tying the person and not allowing him to move, that is like hostage. Okay, they are being tied and they are banned in the room, they cannot come outside the room. Such things are against the freedom or in favor of the freedom. Such things are against the freedom of the person, and if without any reason you put the person behind the bars, or like there was a case where the party police arrest the party to harass him and put in jail for 10 days. You are playing with his constitutional right. Every person have a right of safety and freedom. If you are putting him behind the bars, you are what, you are just depriving him of 10 days of freedom to live his life. How can you do that without any reason? So if you put anyone behind the bar, or put someone a lock in a room, bathroom or house, or not allow him to move from one place to another place, such unauthorized thing is called as false imprisonment, and such is also called as a tort. Are you understanding this? Are you getting this? Yes or no, friends? So basically, what is that is false imprisonment means the unauthorized restraint on person's body. Are you in a permission stopping anyone, or you don't have a permission? Unauthorized, without permission, you are putting a restrictions on the person body, on his movement from one place to another place, and it is a serious violation of the person's right. See this, it is a serious violation of person's right and liberty, whether confined within the four walls or being prevented from leaving a place where he is. If you are locking a person in your house, is it a tort or not a tort? Please tell me. If you are locking a person inside the house, is it a tort or not a tort? Yes, correct. Swani Nahata, it's a tort. Very clear. Understand. Harshit, very true. Tort. Okay, you are not allowed to do so. So if I'm writing down, I'll just give you more examples here. Understand. Okay, I'll give you, what we are discussing. We are discussing the tort or wrong, which are against personal safety and freedom. The tort or wrong which are against personal safety and freedom. The first is basically battery. What do you mean by battery? Battery means what? Applying force without lawful justification or without his consent. Second is assault. Assault is any act which which creates impression that battery will be committed. And third is okay. First is battery, second is assault, third is false imprisonment. Okay, false imprisonment means restraining restraining anyone from moving from one place to another place is called as false imprisonment. Fourth is malicious prosecution. Malicious prosecution. So what is malicious prosecution? Can you explain me in the comment section? What is malicious prosecution, friends? Tell me. See, battery is applying the force. Assault means trying to create that he will apply the force. Okay. False imprisonment means to tie a person and not let him move. What is malicious prosecution? See, when the party, spelling mistake, when a party is filing a wrong case only to harass the other party, create discomfort. Suppose example, there is a fight between two friends. The one friend, just to bully the other person, is filing a case. A wrong allegation is put, and now this person time, effort, money, fame is being destroyed. Very clear. Suppose example, there are two friends. Suppose one, that is trying to harass the other person, and just to create discomfort, that is, the case is being filed just to create discomfort and to defame him, just to put him into trouble, harassment, and then later on court tell that the other party is right and this party is wrong who is filing a case. Such is called as malicious prosecution. Malicious prosecution means a wrong case just to trouble the other party. Don't you think because of your wrong case the other party time, effort, money is being wasted? The other party fame is being at a threat. Are you able to get this? Yes or no? Yes. So again, that is called as malicious prosecution. Let us understand this. So malicious prosecution means starting a judicial proceedings, generally criminal case, against another without any reasonable cause or probable cause, but just which result into defamation and damage to the personal safety, freedom. That is called as malicious prosecution. So it means what? It means starting a judicial proceedings against, generally which proceedings, criminal case, against another person without any reasonable reason, and it turns in favor of another person, but due to which he damages due to which his reputation, freedom, liberty is damaged. Are you getting this? So this is called as malicious prosecution. Just write down this. Judicial proceedings is filed against another person without any reasonable reason, and it turns in favor of another person, but due to which his reputation, freedom, and liberty is damaged. Are you getting this? Yes or no? So first, what is against the person? That is a tort. That is a tort against personal safety and freedom is battery. Second is assault. Third is false imprisonment. Fourth is malicious prosecution. Fifth is nervous shock. What do you mean by nervous shock? See, nervous shock means you see some incidents which is not having a physical force on you, but it is creating a mental pressure on you. You have seen someone hitting your family and hitting in a very bad manner. Now you are into that stress, you are into that depression. You have seen an incident or accident by which you are going through mental trauma and you are really ill because of that. You are not able to sleep. You are not getting that. Yes, that is disturbance in the mental health. Very true, Sakshi. Correct. So what is my point? Such things which is not having a physical injury but a mental injury, and the person is really not happy with what he's seen, is really disturbed, going with the mental emotional trauma that is called as nervous shock. Very clear? So understand here, only getting a nervous shock is not enough. Causing nervous shock itself is not enough. Some injury or illness must take place as a result of emotional disturbance, fear or sorrow. Emotional disturbance, fear or sorrow, that is called as nervous shock. Do you understand this? Yes or no? Yes or no? So you have seen an accident, incident, someone murdered and with hitting 20 times the knife, because of which you for 20 nights you are not sleeping. Is it a nervous shock? Yes or no? Yes. And the last is defamation, attacking on the reputation of the person. Attacking on the reputation of the person. Many defamation cases are filed by one politician to on another because they are just trying to defame the family. It is in Hindi called as manhani ka case. What we'll talk in Hindi, it is called as manhani case, defamation case. Okay, defamation case on Rahul Gandhi by, see, Rahul Gandhi appears before the Surat court in defamation case. Rahul Gandhi appears before the defamation case is filed against Rahul Gandhi. Okay, this happened and now in 2021 also. Okay, defamation case against Rahul Gandhi. Reconsider BJP MLA plea to examine four witness to this. Something he said, something happened, and there was some whatever maybe. Okay, so what is the thing? Without any reason, if you are blaming anyone, without any reason, you are tarnishing their image. You are spoiling their image. You should have evidence. If you have an evidence, can you defame the person openly? Yes or no? If you have an evidence, can you defame the person openly? Yes or no? Answer is yes. But without evidence, without any reason, you are defaming someone. That, array, someone, just imagine if your name is being spoiled in your society, people will look you in that wrong angle. They will not respect you. It is impacting your liberty and the freedom in your life. Understand here. So if someone is defaming you without any reason, you have a right to take action which is called as defamation. Do you understand? So defamation are of how many types? Defamation are of two types. One is libel and one is slander. When it is in temporary form, when it is in temporary form, it is slander. And when it is permanent form of defamation, that is libel. If you make a movie and defame someone with the help of a movie, that is libel. When you orally tell something which is not recorded, that is temporary form, that is slander. Are you understanding? So tell me friends, permanent form is called as libel. Repeating again, permanent form of defamation in the form of videos, cinematography, music recording. You are made a song and you are, in the song you are insulting someone. That is which form of defamation? Libel or slander? That is which form of defamation? Libel or slander? Yes, it is libel. Very, very clear. But if you have given abusive word to the person in oral form, that is which form of defamation? Libel or slander? Harshit and Anisha going right. Harshit, very good. Slander it is. Anisha, A, slander, correct. So guys, the more permanent form, more the punishment. More permanent form, more the punishment, and more the temporary form, less the punishment. Very clear. So understand here, punishment for libel is more, punishment for libel is more, and punishment for slander is comparatively less severe. Punishment for slander is comparatively less severe. So guys, we have done 6 points. What are the 6 points? What are the 6 points we are discussing about those wrong which are against, those wrong which are against personal safety and freedom? The first is battery, second is assault, third is third is what? Third is false imprisonment. Fourth is, okay, malicious prosecution. Fifth is false imprisonment. and sixth is basically defamation. In defamation, there are two types, that is libel or slander. Please read this. Any query here? Please ask. Yes, that is nervous shock. Correct. Fifth is nervous shock. Correct, correct. Yes, bodily harm will come in battery. There is one comment, that is bodily harm. Swani, Nahata, it will come in battery. Is that fine? Fine. So with this, we have talked about what are the wrongs which are against the person's safety and freedom. Now we are talking about what are the remedies available to. What are the remedies available through court and what are the remedies available without the help of the court. Obviously, first you will try without the help of the court extrajudicial remedies. And if not possible, then only you will go to the court. In court, you will go and ask for damage. In court, you will go and ask for injunction, stay order. Getting the point? So remedies. When there is a problem, there is a remedy in the law, and the remedies are of two types. If I'm talking about, okay, kahi na kahi, understand here, judicial remedy and extrajudicial remedy. When it is a judicial remedy, means what? Judicial remedy means there is a damage, there is injunction and restitution, taking back your property. Someone has taken your phone without your permission. Can you file a case and take back your phone? Someone has taken your phone, mobile phone, without your permission and is not ready to give. You have that secretive data, bank balance, everything. Can you file a case and recover the phone? Tell me yes or no. Someone is entering your property, land, without your permission. Can you get a court order to stop the party from entering the land? Yes, that is injunction. And someone has done tort. Can you recover damage from him? Yes or no? So all these are judicial remedies, that are damage, injunction and specific restitution of property. I am repeating, that is damage, injunction and specific restitution of property. Are you getting this? Yes or no? Are you getting this? Yes or no? Correct, guys? But without the help of the court, there are other six methods: self-defense, prevention of trespassing, re-entry of land, recapture of goods, abatement of nuisance, and distress damage feasment. Sir, what are these six extrajudicial remedies? What are these six extrajudicial remedy? I'll discuss that. Understand here. See, the first is self-defense. If a drunkard is entered your house and there is a risk on you, someone is found in your room without your permission, to protect yourself, can you attack reasonably and remove the person? Obviously, you will give a warning first. If the person is not listening, can you have a reasonable force and remove the person? Court will come later on. First, you will try to rescue yourself, right? So, can you do self-help and self-defense and protect yourself? Answer is yes. Answer is yes. That is called as self-defense. That is called as self-defense. Are you understanding this? See this. It is lawful for any person to use reasonable force to protect himself or any other person against any unlawful use of the force. See, someone is attacking you, someone is entering your house, someone is coming and touching you. Can you do the self defense? Someone is touching your family member. Can you do the self defense and help the family? Yes or no? Answer is yes. Very, very clear. So, first tell me, how many remedies are there? There are two remedies. First is judicial remedies and second is extrajudicial remedies. What is judicial remedies? With the help of the court. And what is extrajudicial remedy? Without the help of the court. First, I want you guys to note down this chart. Write down this chart first. Write down this chart. Okay, so have you written this chart? The first is what? That is judicial remedy, and second is extrajudicial remedy. In judicial remedy is with the help of the court. It is with the help of the court. And extrajudicial remedy means without the help of the court. One by one we'll be discussing this. Are you guys connected? Please ping me yes or no. Tell me faster. Are you connected? Yes. Are you connected? Very good. Self-defense. Can you apply reasonable force to protect yourself and your family? Yes. Someone is entering your property without your permission. First, you will warn him. Please stay outside. Don't enter the house. If he's not listening, can you push him and remove the person? Yes or no? Or do you need to ask court, hello court, can we, there is a person entering our house without our permission. Please tell him to go. So basically, friends, my point is you cannot do that. You cannot do that. First thing is you will apply reasonable force and prevent the trespassing. Prevent the trespassing. It very commonly happens in open land. There is a private land and people, their private land which is being, obviously fencing is done, but people use it for transport shortcut. You're not allowed. They put a board, this property is a private property, trespassing will be prosecuted. Have you seen such thing ever? In open land they put the board, this property belongs to Mr. So, and if any person enter the property without the permission or trespassing will be prosecuted and legal action will be taken. Yes. So can you prevent the party from entering the land? Yes, 100% yes. The first remedy is self defense, to protect yourself. Second is someone is entering your land without permission, can you stop him? Yes. Second is prevention of trespassing. Third is re-entry of land. Suppose example, I am on a holiday, so my parking is being occupied by someone else. When I come back, I see my parking is a private parking and anyone else has parked the vehicle. I click a photo and put in the society group and tell, please remove the car. Watchman come and remove that two-wheeler car. And now I park my car. Can I take back my parking and use my parking? Yes or no? Can I take back my parking and use the parking? Yes or no? Yes, that is called as re-entry of land. The person who is wrongfully dispose the land may retake the possession of land, and if he can do so in a peaceful and reasonable manner. Don't fight, don't hit him. First give him a notice, please remove your bike, please remove your car. Intimate him, give him a time to remove it. Don't come and do fighting, that is not allowed. But you can take back your parking, that is called as re-entry of land. Same way, someone has taken your mobile phone, friends do it. Lot of secret nowadays in mobile phone. So now you take your friend's mobile phone, snatch it, keep it to yourself, and now you're not giving or returning it. Can your friend take back the mobile phone? Yes or no? Can your friend take back the mobile phone, friend? Yes or no? Tell me. Yes. Like you can take back the parking. Can you take back the goods? Yes. That is recapture of goods. And there are more two things, that is abatement of nuisance and distress damage feasment. Abatement of nuisance and distress damage feasment. These two things students don't understand very soon, but I'll explain that, don't worry. What are the remedies? First remedy is self defense, second remedy is prevention of trespassing, third remedy is re-entry of land. Fourth remedy is recapture of goods. Now I am talking about more two remedies. But before that, tell me, what are the remedies for what? Judicial remedy, judicial remedy and extrajudicial remedy. Judicial remedy is, the first remedy is, if I'm talking about, okay, claim damages. Second is injunction, and third is restitution, to take back. Correct. What are the extrajudicial remedy? In this case, self help, prevention of trespassing. Third is re-entry of land. Fourth is recapture of goods. Fifth is, what is fifth? See, abatement of nuisance. Do you know this? Tell me, friends, yes or no. Do you know this? Do you know this abatement of nuisance? Tell me yes or no. Harshit is telling yes. Very good. Harshit, can you unmute and talk? What is this? What about others? Okay. I'm talking about abatement of nuisance. Understand here. What is abatement of nuisance? Suppose example, I'll just take example here. There are two bungalows next to next, which is there. There is a bungalow A and there is a bungalow B. In bungalow A, there is Ramlal, and bungalow B, there is Shamlal. Bungalow B, there is Shamlal. Okay. In bungalow B, there is a tree which is having branches and spreading till bungalow A and entering A's house and creating a ventilation problem. Now, there is disturbance and there is a thought and there is something which is right of property is being deprived. So now A will give notice to B, please cut the trees. Now B is not listening even after giving notice. Can A go and cut the branches and save himself? Can he go and cut the branches like this and reduce the tree? Yes or no? Can he stop the nuisance on his own by cutting the tree himself? Yes or no? My question is, A has given a warning, B, please cut the branches. The branches is extended to his house. Okay, that is creating a disturbance. Now, in that case, can A give notice to B? And if B is not listening, can A go and cut himself the branches? Obviously, he should do very less damage to B, and obviously he should use a reasonable method so there is less loss. But to stop the nuisance himself, can A go and cut the trees? Yes, that is called as abatement of nuisance. See, for abatement of nuisance, there is example written: the occupier of land may lawfully abate and stop any nuisance which is injuriously affecting it. Thus, he may cut overhanging branches as spreading roots from the neighbor's tree upon giving notice, choosing the less mischievous method and avoiding unnecessary damage. By giving notice, selecting the less mischievous method and avoiding unnecessary damage, by this way, can they abate the nuisance? Yes or no? Answer is yes. Can he stop the nuisance? Can he hold the nuisance? Can he put a break to the nuisance? Yes, but he should give notice for that. He should use a reasonable method and less mischievous method, and he should avoid unnecessary damage. Then only this is possible. Please read this. and last is distress damage feasment. See, again I'm telling how many remedies are there. Extrajudicial remedy, self-help. Okay, self-help. Then if I'm talking about prevention of trespassing, then re-entry of land, recapture of goods, and distress damage feasment. Okay, next is, that is distress damage feasment, and we have done abatement of nuisance. Now we are coming to distress damage feasment. Any idea what is this? See, till the time you don't get the damage, keep the goods with yourself. Till the time you don't get the damage, keep the goods with yourself, and the day you get the damage, return the goods. Sir, example, best example is Tarak Mehta Ulta Chashma, whereby Tarak Mehta Ulta Chashma, you see Bide and Tappu always fight on a cricket. Now Tappu hits a six, and which the ball is into Bide's home, and they damage and hit the window, and now window glass is being, the situation. Now, Bide will come and take all the bat stump and tell, repair my window first, and then I'll return the bat ball stump. Otherwise, I'll not return. Now, the things with which damage was done is being seized and taken into custody. The day they repair the window and the damage is being cleared, then he will return the goods. Such thing of seizing the goods till the damage is being paid is called as distress damage feasment. Example, if your cattle come to my land and destroy my farm, can I seize your cattle and tell, first pay me my damage, then I will give your cattle? Tell me yes or no. So what I'm doing, I'm taking in my custody your cattle to recover the damage. I'm taking in my custody your cattle to recover the damage. This is called as distress damage feasment. This is called as distress damage feasment. So occupier may lawfully seize any cattle or chattel which are unlawfully on his land doing damage therein, and detain them until compensation is paid for damage. This right of is called as distress damage feasment, which are doing damage. You can take in your custody all the things which are damaging it, and that is called as distress damage feasment. So with this, how many remedies we have learned? With this, how many remedies we have learned? How many remedies we have learned? Extrajudicial remedy, there are six. How many extrajudicial remedies? Six. And how many judicial remedies we are learning? Three. Okay. In judicial, there are damage, injunction, restitution. And extrajudicial, there are six. One is self-help. Second is prevention of trespassing. Third is re-entry of land, recapture of goods, distress damage feasment, and abatement of nuisance. Please read this. Yes or no? Now let us develop, understand. There is a very important concept called as vicarious liability. See what we have discussed. What is a tort? What is a tort? Tortum and wrong. Very clear. We have discussed elements of tort. Yes or no? We have discussed elements of tort. Then we have come to what are the tort which are against the personal safety and freedom. Then we have come to remedies of tort. We have come to remedies of tort. Now I am coming to vicarious liability. What is vicarious liability? Any idea? Please put in the comment section, friends. See, I'm going very fast because I need to cover up many things. I cannot sit across and play slow match. Regular batch is already done, right? So we are into quick revision, marathon series, right? So my point is, what is vicarious liability? This is the question to you. What is vicarious liability? What is vicarious liability? Acha, how many knows that? Raise the hand. How many know this? Raise your hand. Vicarious liability concept. Okay, very good. One is Gagan. What about second? Anisha. Okay. What about others? See what happens. I'll tell you what is the concept. Generally, who do the tort is liable for the tort. Generally, who do tort is liable for the tort. Example, if I go and push someone, I am responsible. If I go and hit someone, I am responsible. If I defame someone, I am responsible. It means those who do tort are called as tortfeasor. Those who do tort are called as tortfeasor. Very clear. If Rahul Gandhi is defaming someone, then Rahul Gandhi himself is liable. Rahul Gandhi will be called as tortfeasor. But in vicarious liability, tort is done by one and responsible is another. But in vicarious liability, tort is done by one but responsible is another. There is a very Hindi popular song, तू प्यार है किसी और की तुझे चाहता कोई और है. Do you know? Matlab done by one and responsible by another. I mean that. Tort is done by A, responsible is B. When this is happening, that is called as vicarious liability. When this is happening, it is called as vicarious liability. So understand here, what is the general rule? The general rule is who do the tort will be liable. But in case of vicarious liability, who does not do the tort or who does not do the tort will be liable sometimes. See, understand here. Let us make a chart for this. Vicarious liability. What is the general rule? The general rule is tortfeasor liable for tort. But in certain cases, that is vicarious liability, in certain cases there is vicarious liability, that is tort is done by one and responsible is another. Tort is done by one and responsible is another. Tort is done by one and responsible is another. That is called as vicarious liability. Now let us understand. In vicarious liability, there are four situations. See, what is the rule? Who do the tort will be liable. But what is vicarious liability? Who do the tort? Someone else will be liable. Let us take an example. The very first example is master and servant. If employee does something wrong, can the tort case be filed against master? If employee does something wrong, can the tort case be filed against master? Answer is yes. Answer is yes. See here. Okay. Simple. If master does something wrong, see, master is liable for the tort committed by the servant while he is acting in the course of job or employment. When the servant is acting in a personal capacity, then he is liable. But when the servant is acting during job and he does something wrong, can the tort case be filed against the master? Answer is yes. Very, very clear. So understand here, let us take the case that is Century India Company Limited versus Northern Ireland Transport Board Limited. What is the case? The director of the petrol lorry, while transferring the petrol to underground tank, he struck a matchstick for a cigarette and he lighted matchstick was thrown on the land, because of which petrol pump was under fire. Now, it was a mistake of the employee. Can the petrol pump file a case against the company? Yes or no? It was a mistake by the employee. Can the petrol pump file a case against the company? Tell me yes or no. Are you getting my question? I am repeating. See, there was a petrol truck, and from the petrol truck, the petrol was being transferred to underground tank. While this was happening, the employee of the petrol truck, he lighted a matchstick, put cigarette on, throw the matchstick on the ground, because of which petrol pump is under fire. Now the mistake is of the employee. Can the petrol pump file a case against the company? Answer is yes. Vicarious liability, any wrong thing done by the servant, master will be liable. Any wrong thing done by the servant, master will be liable. Vicarious liability. Same fashion. If there is principal and agent, if agent does something wrong, can the case be filed against principal? Yes or no? If agent does something wrong, can the principal file a case? Yes or no? Yes, there is again a landmark case. The case is Lloyd versus Great and Smith and Company. See, there was a solicitor, but advocate firm, and they sent their clerk to a client lady, old lady. Clerk did what? He made a papers, fraud papers, transferring all the property of the client in his own name, and the lady under the trust signed the papers. Now, clerk did fraud during his job. Example, there is a firm of partners who are advocate and they send their client, send their clerk to the client. Clerk drafted all the papers in his favor, all the property. Lady signed the paper. There was a fraud done. If there is a fraud done by the agent, can the client file a case against the principal? Yes or no? If there is a fraud by the agent, can the client file a case against the principal? Yes or no? Yes, answer is yes. Read this case. Lloyd versus Great Smith and Company. The managing clerk of the firm of solicitors, that is advocate, by acting in ordinary course of business, committed fraud against a lady client by fraudulently inducing her to sign the documents transferring her property to him. He has done so without the knowledge of the principal who was liable because the fraud was committed in the course of employment. I am repeating again. The managing clerk of the firm of solicitors, while acting in the ordinary course of business, committed fraud against the lady client by fraudulently inducing her to sign the document transferring her property to him. He has done so without the knowledge of the principal who was liable because the fraud was committed in the course of employment. Read this case. Okay, are you understanding this? So this was your second case, that is principal and agent. Okay, there is independent contractor, and there is employer. I am asking you a question, you have to answer. There is independent contractor and there is employer. If any wrong done by independent contractor, employer will be liable or not liable? If there is independent contractor and there is employer, if anything wrong done by the independent contractor, employer liable or not liable? Tell me. What do you think? Suhani Nahata is telling no. What about others? Neha, Anisha. My question to you is, my question to you is, there is an independent contractor and there is employer. If any wrong done by independent contractor, employer will be liable. Vicarious liability there or not there? Answer is not there. I'll take an example. I'll take an example. Suppose I am a mechanic. Example, I am a mechanic and I am repairing Amitabh Bachchan's car. His car is being repaired by me. I am the mechanic, I am the owner. Okay. Now I did not do the repairing correctly and there is a brake fail. Amitabh Bachchan car is driving on the highway and Amitabh Bachchan car hit Salman Khan's car. Okay. Salman Khan approached against Amitabh Bachchan in the court of law. Amitabh Bachchan proved that our car was technically not done correctly by an independent contractor. Our car was not repaired by an independent contractor, Mayur Agarwal, properly. So why we are responsible? He has done some wrong. So prima facie, Salman Khan can file a case against Amitabh Bachchan, but in the court of law, my mistake, will Amitabh Bachchan will be liable? Answer is no. Employer is Amitabh Bachchan. I am independent contractor. I do any mistake. Is Amitabh Bachchan liable as an employer? Answer is no. He can prove that the service was wrongly delivered. Please catch Mayur Agarwal and take action against him. He is not liable. Do you understand this? Yes or no? So if there is wrong done by independent contractor, employer liable or not liable? See, master servant, yes, there is vicarious liability. Principal agent, yes, there is vicarious liability. Independent contractor, employer, no vicarious liability. But in certain cases, independent contractor, and employer, there is vicarious liability. The landmark case is Rayland versus Fletcher case. The landmark case is Rayland versus Fletcher case. Generally, if independent contractor does anything wrong, employer is not liable. Amitabh Bachchan is not liable. But in exceptional cases like Rayland versus Fletcher case, if independent contractor does something wrong, employer is liable. Do you know the case Rayland versus Fletcher case? Tell me. Yes or no? Do you know the landmark case Rayland versus Fletcher case? Yes or no? Waiting for your response. Tell me, friends. Anisha A is telling yes. What about others? Very important case. I am repeating again. See, if any employee does something wrong during job, is the owner liable? Yes. If agent does something wrong, is the principal liable? Yes. If independent contractor does something wrong, employer liable? No. But in certain cases, that is Rayland versus Fletcher case, if independent contractor does something wrong, then the employer is liable. I'll show you one of the video on from YouTube to explain you this. Hold up. You example and idea what is exactly Raylan versus Fletcher case. Understand. So there are two adjacent land. In this one land there is mill and another land there is coal mining. Okay. There is a mill and there is a coal mining. Very very clear. Now let us understand this. Raylan versus Fletcher case. Okay. Now the mill belongs to B and the coal mining belongs to A. Now they wanted water reservoir. So they appointed C, an independent contractor, to make the reservoir. Now, when they were digging the land, they have digged the land, but below that there was again a shaft, means a hollow place. The independent contractor did not check it. So if he would have checked it, so they would have covered the shaft. the gap. Okay, suppose this is a land. I'll just make a diagram. You'll understand it better. Okay, this is the land, and there is this digging. Okay, till there is land, and now below this there is a shaft, hollow place. Okay, and then again there is land. Okay, then again there is a land. They started digging it, and they have digged this much. They have digged this much for making a reservoir, but they did not check the shaft area. Now, independent contractor did not verify what is below the digging area. He filled the water, water filled in. They gone to the shaft and gone to the neighboring area in the coal mine, and the whole coal was destroyed. So basically, now the neighbor filed a case against B. Neighbor filed a case against B. You have done something wrong. B is telling that it is not my mistake. It is the independent contractor who I have given the contract, I have paid money. It is his mistake. So this matter approach court of law. A is filing a case against B. B is telling that I am not liable. It is the independent contractor liable. Take action against the independent contractor. Court said that even though independent contractor has done tort, but we will held responsible the employer, and there is a vicarious liability against B. Are you getting this? There is vicarious liability against B, which happened in Rayland versus Fletcher case. For vicarious liability in Rayland versus Fletcher case, there must be two things: non-natural use of land, non-natural use of land, and second thing is escape from land. If these two things happen, escape from land. Sir, what are these two things? See, reservoir was naturally already there or you artificially made it. See, certain reservoir was already there and naturally you fill the water and it burst out. Then that's not your mistake. You have done natural use of land, but you made a reservoir. So this is non-natural use of land. And when you fill something, you gather something, and the water you have gathered there and it is escaping, then that is your mistake. Even though independent contractor was at mistake, but we are creating vicarious liability. Employer will be liable. B will be liable to compensate A under Rayland versus Fletcher case. And now, if independent contractor does something wrong, in case of Rayland versus Fletcher case, employer will be liable. Employer will be liable. Are you listening, friends? Are you listening? Yes or no? Yes or no? So I'm repeating again. Generally, what is the rule? If independent contractor do something wrong, who is liable? Generally, what is the rule? If independent contractors do something wrong, who is liable? My question to you is, if independent contractor does something wrong, who is liable? Independent contractor is liable. But in Rayland versus Fletcher case, if independent contractor does something wrong, who is liable? Employer is liable. Very, very clear. For that, how many conditions are there? Two conditions are there. What are the two conditions? Please tell me. What are the two conditions? First condition is non-natural use of land, and second is escape from land. So understand here, let us see. Vicarious liability. Tort is done by one and responsibility is of another, that is vicarious liability. Servant does something, master liable, vicarious liability. Agent does something, principal liable, vicarious liability. Employer does something, independent contractor not liable, no vicarious liability. But in Rayland versus Fletcher case, employer does something, independent contractor liable, vicarious liability is there, for which there are two things. First is non-natural use of land, and second is what called as, the second is escape from land. Do you understand this? Let us read the landmark case. See, the B, a mill owner employed independent contractor who have apparently competent to construct a reservoir on the land provided for water for the mill. There were old disused mining shaft under the site of reservoir which contractor failed to observe because they were filled with earth. The contractor therefore did not block them. When the water was filled in the reservoir, it burst through the shaft and flooded the plaintiff, means the neighbor who is filing a case, plaintiff coal mine on the adjoining land. This what happened? Read this. Now question, whether B is still liable even though he is not as at fault as the appointed independent contractor. This is the question. Read this. Okay, so let us read the case. What is the conclusion? What is the conclusion? The conclusion is, understand here, the conclusion is the true rule of law is that who is or for his own purpose brings on his land and collects and keep. If I keep some animal and that animal run and he go and bite the neighbor, who is the responsible? Animal or me? If I get an animal and keep at my place, that animal is running from here and there and you bite my neighbor, who is responsible? I am employer responsible. Do you understand? So anyone get for his own purpose anything on the land and keep them to do mischief, if it escape, must keep a peril, and if he does not do so, prima facie he is responsible for the same. Are you able to understand this? So this was Rayland versus Fletcher case. Do you understand? But see, understand here. We are talking about vicarious liability. What is vicarious liability? What is general rule? General rule is who does the tort will be liable. But in vicarious liability, tort is done by one and the responsibility is of another. Servant does something, master liable. Agent does something, principal liable. But employer does something, independent contractor does something, independent contractor does something, employer not liable. But as per Raylan versus Fletcher case, which is exception, independent contractor do something, employer is liable, and in that case there is two rules. The rule is non-natural use of land and escape from land will be called, then the independent contractor does something, employer will be liable, but there are certain exception. What do you mean by exception? What do you mean by exception, friends? See, in exception, in case of exception, even if independent contractor do something, employer not liable. In case of exception, not liable. Suppose example, B constructed reservoir with the permission of A and for the benefit of B as well as A. B have made the reservoir with the permission of A. Now, if contractor do something wrong, is B liable? Tell me. I am repeating my question. I am repeating my question. If B constructed a reservoir with the consent of A for the benefit of A and B both, now if independent contractor do something, is B liable? Yes or no? Anisha, answer is no. What about others? Neha, Anisha, Sakshi. Sakshi is telling no. Very good. Answer is no. If B makes a reservoir, okay, B makes a natural use of land. There is a reservoir already there. There is a reservoir already there, and by rain the water fills, and there is a burst. The reservoir burst out and go to the neighboring land. Now tell me, for this case, who is liable? Now tell me who is liable? Employer liable or not liable? He makes a natural use of the land. Who is liable? Employer liable or not liable? Friends, please tell me. Not liable. Very clear. Or there is natural disaster. There is so flood that the reservoir bursts out and go to the neighboring land. There is huge flood which is not in your hands. There is natural disaster now because of which you are not liable. Tell me, employer liable or not liable? Not liable. Very clear, guys. Right? So see, if you do make a reservoir, if you do anything with the consent, then you are not liable. If you make natural use, then you are not liable. There is natural disaster, then you are not liable. If you make a reservoir and your neighboring friend A come and destroy the reservoir on his own, and now only he is suffering, all the water is drained to his place. The dot is due to his own mistake. He comes and hit the reservoir with a rod, and now the reservoir is leakage is there, and the water is flowing to the neighboring land. Tell me now, employer liable or not liable? Employer liable or not liable? Please comment. Suppose I have a bungalow, and in the bungalow I have parked a horse, and there is a neighboring friend. I stay in bungalow A. There is neighboring friend B. I have parked a horse here. This is not a horse. Just example. Okay, diagram example. Now he comes and remove the rope of the horse. Now horse goes to his garden and destroy the garden. Who is liable? A liable or B liable? Employer liable or neighbor liable? It is the neighbor liable. Employer is not liable. It is the mistake of the neighbor himself. It is the mistake of the neighbor himself. Do you understand this? Yes or no? So there are certain exceptions which we have to talk about. There first, if you have done natural use of land, or you have made a reservoir with the consent of plaintiff, you have made a reservoir with the consent of plaintiff, or you are doing government duty, government has said you to make a reservoir, or government is making a reservoir, then you are doing statutory duties, or there is natural disaster, that is act of God, or escape is due to plaintiff own default. The neighbor has come and hit the reservoir, or third party come and hit the reservoir. You have made it properly, but someone has hit it and damaged the reservoir, due to which the water is flowing to the neighboring land. All these cases are exceptions to Brilliant versus Fletcher case, and these are the exceptions to the vicarious liability. I'm writing down here. Just hold on. Exceptions to Brilliant versus Fletcher case. First exception: natural use of land. Second exception is consent of plaintiff was taken. Third exception is natural disaster. Fourth exception is statutory duties. Fifth exception is plaintiff's own default. And sixth exception, third party default. Okay, please read this, write this. Are you getting this? Are you friends there? See, again, natural use of land, I am not liable. I have taken the plaintiff consent, I am not liable. There is natural disaster, I am not liable. I am doing government duties, I am not liable. Plaintiff is at his own fault, I am not liable. Third party comes and damage the reservoir, I have taken all the action, I am not liable. So all these are cases where Raylan versus Fletcher case is not liable. Employer is not liable for any mistake by the independent contractor. Employer is not liable for any mistake by the independent contractor. Now I am coming to absolute liability. See, what law is telling that? Law is telling that as a landmark case. Okay, there is a landmark case, MC Mehta versus Union of India and other case. Union of India means government case. See, law is telling that those industries who are handling dangerous nature of goods, chemicals, dangerous chemicals, gases. Do you remember the Bhopal gas tragedy? It was the world dangerous industrial disasters. Okay, and now still we are suffering with that Bhopal gas tragedy. And after that case, we come to this landmark case, MC Mehta versus Union of India case. What happened in Bhopal gas? Whether there is natural use of land or non-natural use of land, whether there is escape or no escape, but because of which, because of them, if any life is at threat, there is absolute liability. There is no that two conditions required. See, for vicarious liability, there are two conditions. What are the two conditions? We have written down the two conditions. The condition is non-natural use of land and escape from land. The two condition is are basically non-natural use of land and escape from land. But whether there is natural use or non-natural use, if you're dealing in hazardous goods, these two conditions, whether you do it or don't do it, because of hazardous goods and hazardous chemical, if any life is at threat, you are liable. If any life is at threat, you are liable. That is under MC Mehta versus Union of India case. There is absolute liability, no delegable liability, no debatable liability. Who is dealing in hazardous chemical, whether they fulfill these two conditions or don't fulfill these two conditions, but still there is a liability which is called as absolute liability. Are you guys understanding? Are you listening to me, friends? Are you connected? Tell me yes or no. Yes. Pawan is listening. Okay. Okay. Achyut is listening. Okay. So let us read this. Sakshi is listening. We are of the opinion that enterprise which is engaged in hazardous or inherently dangerous industry which possesses a potential threat to the health and safety of the person working in the factory and residing in the surrounding owes an absolute and non-delegable duty to the community to ensure no harm result to them on account of any hazardous or inherently dangerous activity which has undertaken, which is MC Mehta versus Union of India case, whereby absolute liability, no question, no conditions, you are liable. Employer is liable whether your mistake is there or your mistake is not there, which is called as absolute liability. But for vicarious liability, there have to be fulfillment of two conditions, then only the vicarious liability takes place. Are you getting this? Yes or no?